Hello, my name is Christoph Safferling. I'm standing here outside the Palace of Justice in Nuremberg, the very place where the Nuremberg Trial took place in 1945-46. I've written a book which is called, in English, The Powerlessness of International Law. And obviously I'm talking about Nuremberg and the United Nations and the development of international law in this book. And in order to read a chapter out of it, I'm going to go and take you inside the Palace of Justice. So I'm sitting now here in the deliberation room. On the very desk, the Nuremberg judgment was actually drafted. So now I'm going to read out a little chapter of my book, War Crimes in the Dock. On August 8, 1945, the Charter of the International Military Tribunal was adopted as an annex to the London Agreement. The four victorious powers, the United States of America, the United Kingdom, France, and the Soviet Union, supported by 17 other states, had agreed on a course of action to resurrect the political guidelines of the 1943 Moscow Declaration and to conduct criminal proceedings. This was precedented by, at times, heated debates at the Moscow Declaration was interpreted differently. For Stalin, bringing the perpetrators to justice would have been accomplished by court-martialing and summarily executing 50,000 German officers by firing squad. Churchill was enraged by this proposal. However, he too had reservations about whether ordinary criminal proceedings were the appropriate response to war crimes. After all, such proceedings would always have borne the risk of an acquittal if the defendant's guilt could not be proven. The treatment of Germany was also contentious in the US. US Secretary of the Treasury, Henry Morgenthau, ultimately failed to persuade President Roosevelt to accept his plan to deindustrialize Germany and shoot the German arch-villains. Secretary of War, Henry L. Stimson, had argued against this, saying that the Germans should not be subjected to the same crimes as those they had committed against their victims. Instead, the leading Nazis should be brought before an international tribunal with at least a modicum of procedural rights. For a long time, it was assumed that there would be a trial against Adolf Hitler and Joseph Goebbels, which would be completed within 3 weeks. It is common knowledge, though, that the two Nazi leaders evaded trial in April 1945 by committing suicide. The criminal proceedings against 24 defendants, the dock did not have enough room for more, which were then held in the Palace of Justice at Nuremberg, in the room next door, ultimately lasted almost a year. Compared with today's international criminal trials, which last an average of 7.5 years, this is little more than the blink of an eye. Churchill's skepticism and Stalin's insistence were countered only by the persistence of the United States in its determination to bring Nazi leadership to trial under the rule of law. Robert H. Jackson, a confidant of Roosevelt, proved to be particularly influential in the spring of 1945. Jackson had been appointed to the US Supreme Court in 1940, thus reaching the apex of the legal profession at the age of 48 in Washington. Previously, without ever having graduated from law school, he had pursued an impressive career, first as a lawyer in New York and then at the Department of Justice in Washington. The brilliant legal thinker was committed to following his clear inner moral compass. He believed firmly in the rule of law and, at the same time, possessed a sense of pragmatism and willingness to compromise. The trial opened in October, the 18th of October 1945, in Berlin, in the large hall of the Kammergericht, the Court of Appeal in Berlin. Here, in the absence of the defendants, the indictment was handed over by the prosecutors to the 4 judges and the 4 deputy judges of the military tribunal. The trial then began November 20, 1945, in the converted courtroom of the Nuremberg Regional Court in the highly secure Palace of Justice on Fürther Straße. On the 21st of November 1945, in front of a packed courtroom and 600 and cameras, the US Chief Prosecutor Robert H. Jackson opened the proceeding with the indictment. So far, my little excerpt of my book, The Powerlessness of International Law. Of course, I don't only speak about Nuremberg, but Nuremberg certainly was a change in a moment of international law, together with the foundation of the United Nations. And I also recall the development after the end of the Cold War and then the situation which we find ourselves in. And I hope to show a few ways out of the crisis that we are undergoing at this very moment. Thank you very much for your attention, and I hope you have a good reading of the book. Thank you.